afternoon, and welcome to today's Senate Occasional Lecture, marking 50 years since Neville Bonner was first appointed to the Australian Senate. My name's Rachel Callanan. I'm the Clerk Assistant Procedure with the Department of the Senate, and I'll be chairing today's lecture with Mr. Ben VV, who is the Indigenous Engagement Officer with the Department of Parliamentary Services, and also the Chair of the Parliamentary Service Indigenous Employee Network. Today's lecture is Auslan interpreted and is also being live streamed on the Australian Parliament House website. COVID-safe arrangements are in place, and I remind you to please maintain COVID-safe practices when you're in the parliamentary building. I'll now hand over to Ben for our formal welcome.
Thank you, Rachel. Welcome, everybody. Firstly, I'd like to acknowledge that where we meet today has been the meeting place for the Ngunnawal and Ngambri people for thousands of years. I also acknowledge the cultures of any Aboriginal and Torres Strait Islander people that are joining us here today. We have some distinguished guests with us today. I'd particularly like to welcome Auntie Pat Anderson, chairperson of the Lowitja Foundation, and her sister Claire. We also have members of the Uluru Statement from the Heart team, Mr. Nolan Hunter, Bridget Kammer and Alira Davis. Welcome. Now, today's lecture commemorates the first Indigenous Australian Senator and Parliamentarian, Mr. Neville Bonner AO. A Jagera man, Neville Bonner was selected to fill a casual vacancy in the Senate for Queensland in June 1971 and served as a senator until 1983. On entering the Senate, Mr. Bonner expressed his pride in being the first Aboriginal person to participate in parliamentary proceedings, however long that took. As a senator, he repeatedly drew the Parliament's attention to key issues affecting Aboriginal people, including health, housing, and the disproportionate incarceration rates. Mr. Bonner urged policymakers to meet and consult directly with Aboriginal people and model these practices as the first Indigenous chair of a Senate committee. Crossing the floor 34 times in his 12 years in the Senate, Mr. Bonner is remembered as a trailblazing senator who left a powerful legacy. I'll hand over now to Rachel to introduce Professor Davis. Thank you.
Thanks, Ben. And I am delighted to introduce to you today Professor Megan Davis to deliver the lecture. Professor Davis is Pro Vice-Chancellor Indigenous and Professor of Law at the University of New South Wales. She's also Acting Commissioner of the New South Wales Land and Environment Court and was recently appointed the Balnaves Chair in Constitutional Law. Professor Davis was a member of the Referendum Council and the Experts Panel on the Recognition of Aboriginal and Torres Strait Islander peoples in the Constitution. She's also worked extensively at the international level as an expert member of the United Nations Permanent Forum on Indigenous Issues and is currently a member of the United Nations Human Rights Council Expert Mechanism on the Rights of Indigenous People. Would you all please join me in welcoming Professor Davis?
Sorry, I just took the long way around. I'm just going to put a timer on because, as Auntie Pat knows, I do tend to talk too much or for too long. And just apologising in advance because I've been ill and I'm trying not to cough, but I don't have COVID, sorry. Auntie Pat's raising her eyebrows at me going, it's not the thing to say, Megan. So I guess I'll begin by also paying my respects and acknowledge the Ngunnawal and Ngambri people and their elders on these lands, unceded lands that we meet today, in honour of a man who made the unlikely journey here to Parliament House to be the first Indigenous representative ever in, well, not necessarily here, but in Parliament. I also want to thank Rachel and also Ben for your introductions. And turns out Ben's a cousin of mine. We both come from Hervey Bay, so it's nice to see you. And I also want to echo the welcome to the same people that Ben acknowledged. Any Aboriginal and Torres Strait Islander brothers and sisters in the room. Auntie Pat Anderson, of course, who I've worked with very closely with in terms of constitutional recognition for a long time now, and her sister Claire. And also Nolan Hunter, who I've also worked very closely with on ConRec. The Kimberley Land Council was one of the land councils that led one of the dialogues, and Nolan's been with us through that process and still is. And also my brother from New South Wales. We're not talking till after the State of Origin, Craig Ritchie from Myatsys. And finally, my niece and Bridget and other Aboriginal people here who participated in that pretty incredible process we were involved in, which is what I want to talk to you about today, about the Constitutional Recognition Project in Australia, which in 2021 is entering its 11th year. So it's actually the second decade now of constitutional recognition in Australia. And I want to talk about the Uluru Statement from the Heart and this proposal for a constitutionally enshrined voice to Parliament. And in preparing for today, it was interesting to me that 7 years ago I gave a Senate occasional lecture on constitutional recognition, and it was interesting to revisit that speech that I gave compared to now. So that was 4 years into the decade, and now we're the first year into the second decade of constitutional recognition, and I'm much older and greyer. It's true, Craig. But hopefully we're closer, and that's what I want to talk about in my talk today. In 2014, it was interesting because I was reflecting on the many, at the time, competing versions of constitutional recognition that were swirling around Canberra. One preferred version of constitutional recognition was that it needed to be a symbolic form of recognition, and this was a version propagated by political pundits and politicians and others who promoted this form of symbolism because at the end of the day, I feel they think it's the easiest to do. There is a belief that symbolism is not controversial, and given the very high threshold of Australia's referendum provision, a majority of states and a national majority, that symbolism is the least likely to attract controversy. But that vision of constitutional recognition is not one that was shared by Aboriginal and Torres Strait Islander people at the time, and certainly is not shared now. And I think the Uluru Statement from the Heart categorically ruled that out as being an option, or at least an option on its own. So in 2014, when I was talking, I was deeply concerned with the fact that the political class was at odds with the expectations of First Nations peoples who were seeking substantive constitutional reform. And it was this dissonance that laid the groundwork for the work of the Referendum Council and the Uluru Statement from the Heart, which saw each of the First Nations constitutional dialogues over 2016 and 2017 reject a statement of recognition or symbolism as a viable form of constitutional recognition. So today, in preparing this talk, I was reflecting then on the competing notions of voice now that are playing out. So much has progressed in this constitutional recognition discussion. But there are competing notions of what a voice to Parliament means, the voice to Parliament that emanated from the Uluru Statement from the Heart. There is a difference between the voice envisaged by the participants in the Uluru dialogues, mostly voiceless and pecunious communities, versus the voice as envisaged by the most powerful, a model of a voice to Parliament envisaged by government and bureaucrats of the day whose uncritical devotion to the status quo is an endorsement of their own policies, but manifests in a desire to ensure the footprint of this voice is minuscule and costs very little. The competing notions of voice playing out currently also turn on the purpose and the definition of Parliament. the Aboriginal and Torres Strait Islander people who sought a voice to Parliament in the Uluru Dialogues have been told on a number of occasions by the co-design leadership group who are leading the interim voice design that the line between Parliament and government that they envisage is imaginary. It's been called flimsy and false, which is really an astonishing diminution of the symbolic and substantive role that Parliament does play as both representative and accountable to the Australian people. So the lecture is, of course, in honour of Neville Bonner, and I wanted to reflect on the fact that the dialogues, in essence, eschewed a non-discrimination clause as recommended by the expert panel for upfront political empowerment, which is the voice to Parliament. They chose an enhanced participation in the democratic life of the state, a voice to Parliament. And Neville Bonner was, of course, our first Indigenous voice in the Parliament. And while he advocated for more Aboriginal representation in the two houses, I want to talk today about why the voice to Parliament does align with much of his vision. That is to say, I read as much as I could of his comments around these structural reforms, not Uluru, but in his day, in Hansard transcripts and his biographies and many articles that have been written about him. And there was a great alignment with many of the things that were discussed in the dialogues, including an inherent suspicion of the states and territories, and the importance of the Commonwealth and the Commonwealth Parliament and Indigenous people's engagement with the Parliament. He, of course, was severely criticised because he felt that we should engage more with Parliament than activism on the streets. But he also had really interesting things to say about treaty. His suspicion that a Commonwealth treaty might be ritualistic and not really deliver the kinds of outcomes our people need to improve their lives. So that's really what I want to talk about today. And I've almost finished my 40 minutes, so I'll wrap up now. That's a joke. So what I'm going to do first is just talk a little bit of background about constitutional recognition, and then I want to talk about this notion of a voice and why constitutional dialogues were needed, and then why the proposal of Voice Treaty Truth was the proposal that came out of all of that work, and then finish. So to begin with, as I was saying, you know, when I last gave my Senate occasional lecture, we were barely 4 years into this constitutional recognition decade. And as I said, we were deeply concerned about symbolism being the primary form of recognition that would go to the Australian people. And at the time, I titled that lecture, Competing Notions of Constitutional Recognition, Truth and Justice, or Living Off the Crumbs That Fall Off White Australian Tables, that very famous quote. So 2010 marked really the beginning of that recognition, of this recognition project, on the occasion of Julia Gillard creating an expert panel to take the nation to a referendum on Aboriginal and Torres Strait Islander peoples in the Constitution. And it was done at the urging of the Greens and the independent Rob Oakeshott and Tony Windsor, in an agreement for Julia Gillard to assume power in the lower house and to form a government. Because up until then, there had been multi-party support in election platforms for constitutional recognition of Aboriginal and Torres Strait Islander people. The problem, though, that would emerge is that it wasn't really specific what that form of recognition was. And who would know then that a decade later, we've had 7 processes and 9 reports, and that the nation would still be waiting for the Commonwealth to act on constitutional recognition. So after 10 years, we have had the Prime Minister's expert panel in 2011. Its final report was handed down in 2012. We had an Aboriginal and Torres Strait Islander People's Recognition Act. It was passed in 2013. Next, we had the Aboriginal and Torres Strait Islander Act of Recognition Review Panel, led by John Anderson, and it reported in 2014. Then we had a Joint Select Parliamentary Committee, which was chaired by Ken Wyatt and Nova Peris. It was started or established in 2013, and they handed down an interim report a progress report and a final report across 2014 and 2015. Then at the end of 2015, we had Turnbull set up the Referendum Council with a final report in June of 2017. Then we had the Joint Select Committee on Constitutional Recognition led by Senator Dodson and Julian Leeser. That was established in 2018 with a final report in November 2018. And now we have the Wyatt Committee looking at putting meat on the bones of the voice, and they handed down their interim report earlier this year in 2021. So this is a lot of work in an area of law reform and public policy. And returning to that 2014 Senate occasional lecture, first and foremost in my mind was that deep concern at the momentum for symbolic recognition, but most of all, we were concerned that Aboriginal and Torres Strait Islander people hadn't been properly asked or consulted as to what was meaningful recognition to them, and that there was very clearly zero appetite in the community for symbolic measures. And it became really apparent then in 2015 that we would need a new process. The expert panel was a panel of experts. You know, I sat on that panel, 24 people sat on that panel. We chose the reforms. At no point had we asked Aboriginal and Torres Strait Islander people, what does meaningful recognition mean to you? And so 5 years, 6 years in, we had to retrofit that process. And that was the process of the constitutional dialogues, which I'll move on to now. So we did meet with Prime Minister Abbott, myself, Noel Pearson, Patrick Dodson and Kirsty Parker, who was the chair of the National Congress of Australia's First Peoples, in the middle of 2015, to say to him, you know, very politely that although he preferred constitutional symbolism, it did not align with Indigenous expectations of constitutional recognition. That in fact recognition is a complex legal and political term or concept, and it can mean many things. So yes, at that point, the public discourse on constitutional recognition in Australia had very rarely risen above the threshold of the dictionary meaning of recognition, which is acknowledgement, which is why everybody assumed it would be a preamble or statement of recognition in the Constitution. But it is the fact that recognition can mean many things. It can mean a statement of recognition, but it can also mean an autonomous region, a state like Nunavut, agreements and treaties, designated parliamentary seats or reserved seats, and it can mean constitutional rights. And so what we hadn't done is go out and talk to people about the very many forms of constitutional recognition and which aligned with their vision of recognition. To his credit, Prime Minister Abbott hosted a meeting of 40 leaders at Curability House with Bill Shorten to seek those leaders' views as to what they thought about the direction of constitutional recognition and a referendum on symbolism. And before I speak to that meeting and its outcome, I wanted to make a few comments then on the shift from a preference for Section 116A, a non-discrimination clause in the Australian Constitution, which was the primary reform advocated by or recommended by the expert panel on the recognition of Aboriginal and Torres Strait Islander peoples in the Constitution in 2012, to this notion of a voice to Parliament. You know, this notion of upfront political empowerment. What had happened in that period that we'd gone from what Tony Abbott called a one-clause Bill of Rights to something which is upfront political empowerment, that although it may not be binding, would require the state to have Aboriginal and Torres Strait Islander people at the table. And I think it was around this time that I became interested in the literature of voice and powerlessness in political systems. And this was the period where Ken Wyatt and Nova Peris were doing their very comprehensive work in that first Joint Select Parliamentary Committee on Constitutional Recognition. And at the time I read all of the Hansard transcripts as they were coming in which the committee was travelling out around Australia to talk to Australians and also First Nations communities about constitutional recognition. And in particular, they would talk to these communities about, you know, Section 116A, this non-discrimination clause, the new race power that we'd proposed, and talking to community about all these recommendations which had been set down by the expert panel, of which I was a member and of which I was very proud. But in reading these documents, it became really evident the sense of voicelessness and powerlessness that was coming out of the pages from our people. It was palpable. And I was someone who'd been a strident supporter of rights and enshrined rights and bills of rights. And, you know, my first job was at the United Nations, and I was trained by UN human rights treaty bodies and believed at that point, being young, uncritically kind of devoted to international human rights and the notion of entrenched rights. And my first job with Professor George Williams as a constitutional lawyer was as the head of the Bill of Rights project at UNSW Law School. And so I suppose in some ways I became a bit frustrated at the response to the non-discrimination clause that we had drafted with so many lawyers and barristers across Australia. But you couldn't help but be moved by these expressions of voicelessness and powerlessness from grassroots Aboriginal and Torres Strait Islander people about how they felt in this mighty polity of ours, this liberal democratic system of ours with an ostensibly robust rule of law and equality before the law. It was a very bleak assessment that was coming across in these Hansard records. And I remember reading one record where they'd gone out to a community and Christian Porter and others were asking the head of an Aboriginal organisation about the savings clause in Section 116A and did they think it was appropriately drafted. And just seeing these kind of exchanges going on between our people and the state on recognition. And so I went away and read as much literature as I could find because, as Craig Ritchie knows, I don't like theory and legal theory, political theory. I was trying to find a place that could explain for me. I saw some raised eyebrows, but I don't mean to offend theorists. Trying to find something that would explain to me what was going on in the community. And there's a lot out there, of course, but the thing that I found most resonant in what I was seeing and reading was some of the writings that emanated from interviews with former concentration camp internees in World War II. And reading a lot of this work, including personal biographies, I came across this concept of what is referred to as ethical loneliness, which is an experience of being abandoned by humanity, compounded by the experience of not being heard. The definition of ethical loneliness is the isolation one feels when one, as a violated person or as a member of a persecuted group, has been abandoned by humanity or by those who have power over one's life's possibilities. It is a condition undergone by persons who have been unjustly treated and dehumanised by human beings and political structures, who emerge from that injustice only to find that the surrounding world will not listen to or cannot properly hear their testimony, their claims about what they have suffered and about what is now owed to them on their own terms. The theory and a lot of this writing talks about being able to voice that experience and then talk to the issue of repair. What does repair look like after injustice? And this is where I think Australia really struggles. Let me go on a little bit further with ethical loneliness. It's caused not only by dehumanisation, oppression and abandonment, but also by the failure of just-minded people to hear well from those who have suffered what recovery or reconciliation after massive violence or long-standing injustice would require. Such failures of hearing haunt sites where the goal is political transition, reconciliation or forgiveness. As such, unassuaged ethical loneliness has very serious political ramifications. And I believe this goes to the heart of what has been until now a flawed reconciliation project in Australia. And just let me repeat that line: the failure of just-minded people to hear well from those who have suffered what recovery or reconciliation after massive violence or long-standing injustice would require. And so in 2014 and 2015, we had politicians and political pundits and the Recognise campaign talking about symbolic recognition. And I wondered why it was that they cannot hear what it is that our people are saying repair is. This is what is at the core of reconciliation. Recognise the harm that was done and ask, what does the repair look like? And this is, of course, what the recognition exercise is intended to be. Recognition is one of those repair exercises. It's been undertaken by multiple liberal democracies around the world. And in a recognition project, there are two parties. There's the recognisor, the Australian people, and the to be recognised, who are the First Nations people. And both have to agree to that form of recognition for it to have meaning, for it to be repair. And this is why the work of the Referendum Council was so important. And I'm going to talk to that now. It was set up by Abbott and Turnbull in full consultation with Shorten after the Curability meeting. Prior to that meeting with the Prime Minister and Opposition Leader, 40 leaders met on a weekend to discuss what was going wrong with recognition. And they issued the Curability Statement of 2015, which was issued by those 40 leaders in attendance, about what form of constitutional recognition communities were pursuing. And I'll read an extract from that statement. Any reform must involve substantive changes to the Australian Constitution. It must lay the foundation for the fair treatment of Aboriginal and Torres Strait Islander peoples into the future, a minimalist approach that provides preambular recognition, removes Section 25 and moderates the race power, Section 5126, does not go far enough and would not be acceptable to Aboriginal and Torres Strait Islander people. Now, this was said in mid-2015 in a curability statement that was issued to politicians and the media. And immediately after the Uluru statement, of course, we had the Prime Minister and others say, well, where on earth did this come from? This is unheard of. We don't know where this comes from. You've overreached your terms of reference. But if they'd heard, if they'd listened to what people were saying in mid-2015, it would have come as no surprise. Those Aboriginal and Torres Strait Islander curability leaders recommended an ongoing dialogue with Aboriginal and Torres Strait Islander people and the government to negotiate the proposal to be put to a referendum. And these recommendations were the key kind of motivation for the council, the Referendum Council. So that was the period of revolving doors of Prime Ministers, and Abbott left office and Turnbull became the Prime Minister. And despite his reservations, to his credit, he set up the Referendum Council, who began its work in December, I think, of 2015. And now I'm going to talk to why the dialogues were so important and why it underpins the entire process of the Uluru Statement from the heart, the process that the country is now moving through in its second decade of constitutional recognition. In doing that, I do want to acknowledge Auntie Pat Anderson in the audience. I know she'll be mortified, but she did lead that process with Mark Liebler and attended every single constitutional dialogue. And was an extraordinary leader, leading very difficult conversations at a time that our people did not want to talk about constitutional recognition. And I just wanted to acknowledge your leadership, Auntie Pat, Pat Anderson, in a public forum, because no leader I've seen has undertaken such a difficult conversation with our communities. So when we met and we realised we need to run a process now that goes out to our communities who did not have the appetite for more consultation. We had to think of about what kind of process we would run. How do you go out and talk to communities that had been decimated by a policy setting known as the Indigenous Advancement Strategy? Communities were very angry. They weren't provided with a lot of information that was going on at a Commonwealth level about things that were impacting their lives and their homes and their employment. And consultation was a dirty word in most communities, and still is, because of the lack of meaningful consultation that is done in a lot of communities, particularly by local, state and federal governments. And they spoke a lot about that, about the ticker box consultations that go on between bureaucrats and communities, and how people go away from these consultations and never report back to communities what was the outcome of the time that they give freely in communities to these conversations, which are usually a ticker box exercise that meet the KPIs of that bureaucrat or that department, but never a kind of two-way conversation. And so we decided what we needed to do then was to run a process that was structured and deliberative, but allowed the participants to feel like they were in control of the process. And we weren't given a lot of money to do the consultation process because the Prime Minister had been told by a number of people that our mob were over-consulted on constitutional recognition, and really they just wanted a symbolism in the Constitution and get on with their lives. So with the money that we did have, we decided we would walk a sample of First Nations people through a process, a dialogue, that was very tightly structured. So every dialogue had to be run exactly the same way. It involved very detailed and intensive civics, so a very intensive civics program, and a very intensive legal program. And then we had, after all of that kind of first initial education piece, we had an assessment of the legal options that the Prime Minister, Malcolm Turnbull and Bill Shorten had agreed that we could consult the community on, and that included the voice to Parliament and included treaty. We had said to Turnbull, with Victoria having a treaty process and South Australia has a treaty process set up, it's very difficult to go out to communities with the elephant in the room and not talk about agreement making. So it was an option on the options that we discussed with people out in the dialogues. So we decided then we'll go with a dialogue model, and I'll talk to that in a moment. It needed to be bottom up, and we needed to make sure we weren't consulting people in a ticker box way. And there was a lot of pressure on me and Pat and others to do things like the clicker approach. Auntie Pat, people were like, have town halls, get everyone in, put the options up, give them clickers, and then the option that comes up with the top rating would be the proposal to go back to government for a referendum. And the problem, though, with all of those approaches, they even had clicker companies lined up. No one laughed at that. But the problem with that is in a constitutional process like this, you do need people to be informed, deeply informed about both the civics and the legal options for people to come out the other end and feel like they made an informed decision. So we decided on a structure, and then we began a series of meetings across the country to ask for permission from our traditional owners, our cultural authorities, our law councils, land councils, sorry, that's my legal bias, my Aboriginal land councils, national peaks, etc., to run the dialogue that we were doing. We wanted to be consultative with them and say, look, this is the process that we're running, this is what's on the table from the Commonwealth. What do you think about what we're going to do over 3 days? Do you have any feedback, any criticism? And then got the sign-off to run those dialogues. And along the way, obviously building contacts in a lot of communities about who might host and who might work within that dialogue to assist people. So we had a very formal meeting in Broome with traditional owners brought from across Australia and the Torres Strait. Next, we had a meeting in Thursday Island with key organisations, so national peak bodies, community control. And then we had a very robust meeting in Melbourne, which was a meeting of Aboriginal and Torres Strait Islander leaders in the struggle, national leaders, individual leaders, people involved in the movement for a long time. So at these 3 meetings, we ran the dialogue process by everyone, and then we ran a trial dialogue in Melbourne with Melbourne Law School. And that trial dialogue was where we brought people from all over the regions to participate in the dialogues who were going to be the working group leaders so that they themselves can participate in at least one dialogue. And we didn't call them facilitators, we banned facilitators from this process. We had no facilitators, no professional facilitators. They had to be local leaders who knew the local conditions and their local people and can lead this conversation. We did not want professional facilitators. And we also, after the trial dialogue, banned lawyers. So lawyers, except for me, can be very opinionated and they can be know-it-alls. And we had some disasters with lawyers in the trial dialogue, with people who'd done constitutional law in, 1980 and ran everybody down a little alleyway that they didn't need to go. And also the mob defer to experts. So if a lawyer's there, everybody's going to defer to the lawyer, to the expert, and we didn't want that. We had a group of pro bono constitutional lawyers who sat very quietly, honey pat in the background, and were called upon when if we needed them to contribute answers to questions if I couldn't answer them. And so the Referendum Council gave the approval to this dialogue process, and then we rolled it out over 6 to 7 gruelling months. The regional dialogues were convened in Hobart by the Tasmanian Aboriginal Corporation, in Broome by the Kimberley Land Council, in Dubbo by the New South Wales Aboriginal Land Council, in Darwin by the Northern Land Council, in Perth by the South West Aboriginal Land and Sea Council, in Sydney by the New South Wales Aboriginal Land Council, in Melbourne by the Federation of Victorian Traditional Owners Corporation, in Cairns by the North Queensland Land Council, in Adelaide by the Aboriginal Legal Rights Movement, in Brisbane by a number of organisations, and Thursday Island was run by the Torres Strait Regional Authority, the Torres Strait Council and a number of other Torres Strait regional organisations. We also ran a truncated version of the dialogue here in Canberra, which was hosted by the United Ngunnawal Elders Council. And then after all of those regional constitutional dialogues, we ran the National Constitutional Convention at Ulara and Mutijulu at the Rock at Uluru. And for 2 weeks ago, we had the 4th anniversary of the issuing of the Uluru Statement from the heart to the Australian people. And I'll get to that in a moment. I just wanted to talk briefly about that process, the dialogue process. We engaged IATSIS to run it because we didn't want it to be top-down. We didn't want it to be us running it. So the Australian Institute of Aboriginal and Torres Strait Islander Studies helped run the logistics. And they engaged local organisations, and those organisations, mostly land councils, ran the dialogues for us and helped to choose the invitation list. And we chose mostly land councils because we wanted to ensure from the outset, and we discussed this at the very first meeting on the design of the dialogues, that the decision-making needed to be underpinned by the cultural authority. So it had to be underpinned by our traditional owners, and that was really important to the process. The invitation list, therefore, was 60% traditional owners, and then 20% drawn from the local Aboriginal organisations and community control, and 20% from, well, individuals. So you could, some regions, you could apply and write a letter and say why you wanted to do it, and other regions, they just let people rock up. So it would be leaders and grannies and elders and young people and Stolen Gens members and lots of different people. We didn't allow it to go over the subscribed number of people who had to participate for the outcome to be robust. But in places like North Queensland, you had a huge public gallery that was almost more people in attendance watching than participating in the dialogues. So as I said, it was really important that 60% was our traditional owners. I've already made the point about professional facilitators and that the word facilitation and facilitator was banned. It just had to be community-led. We also had a fundamental kind of list of principles that guided the dialogues, the first being impartiality. So we were really conscious of groupthink and people coming in with an agenda, and that was really important. So as we broke up the groups throughout the dialogue, that was first and foremost as well. We wanted everyone to have a voice and not to be influenced by others in a way that they didn't feel like they could talk. Accessibility of relevant information was really critical. So we had our material, translated into 20, 30, 40 Aboriginal languages, Torres Strait Islander languages, sent out across radio, all kinds of media. And then when we had dialogues in places like Ross River, you had a very large number of interpreters who would translate it into 2 and 3 different languages, so that my legal kind of lecture, for example, would take 2 hours in the city, took 6 hours at Ross River, and you had some really rich discussions about law, about their law and about the white man's law. We would come in days and days in advance and work with the interpreter service to make sure that the language that we use they could interpret, and that they would give us words to replace for things like constitution and words that would make it easier for the information to flow. And then the last thing that I think is really key to just impress upon everyone is the outcome had to be signed off by everybody. So the record of meeting, which went to Uluru, everybody had to sign and agree on. And so we would spend hours and hours and hours and hours and hours, honey Pat, every blackfella's a bush lawyer, drafting and editing and re-editing this text. It was like my work at the UN, where they put it up on a big board and everybody has to rip it to bits and put it back together, and then it looks like what it did in the first place. But it was a really important exercise though, because when you went to Yulara, when you went out to Uluru, it wasn't a decision-making process out there. You were just endorsing the work that had been done in the dialogues. So you couldn't have a group of, elites come in and decide, well, no, this isn't right, what we want is this. You couldn't do that. So when we got to Uluru, each group read out the record of meeting. We looked at what was prioritised across the Federation, and that's how the proposals were decided. And the key question is, what is meaningful recognition in your region? What is the exigency of reform in your region? The important thing about dialogue, I think, in terms of us choosing it, is that when you read a lot of the literature and dialogue, it's very much about the flow of the discussion. And it's more about speaking through, not speaking to. And we were influenced by a number of the kind of writings on dialogues, but in particular David Baum's writings on dialogues. And I really like his description of the crucial difference between dialogues and discussion. He says a dialogue can be among any number of people, not just 2. Even one person can have a sense of a dialogue within himself if the spirit of the dialogue is present. The picture or image that this derivation suggests is a stream of meaning flowing among and through us and between us, and this will make possible a flow of meaning in the whole group, out of which may emerge some new understanding. It's something new which may not have been in the starting point at all. It's something creative, and this shared meaning is the glue or the cement that holds people or societies together. And I like that quote because there were 2 really creative things that came out of this dialogue by allowing this, not discussion, but dialogue to flow. The first thing was truth-telling. So I was probably, Pat would admit, a little bit rigid about the agenda and everybody sticking to the agenda. But in the course of the early discussions, in every single dialogue, they started from the same point, and that was to do with truth-telling, about the role that truth-telling had in meaningful recognition, about the role that Australian history had to play in recognition. And this really important refrain that we heard all across the dialogues: why don't they want to know about us and our stories? Why don't they want to know about our experiences in our own country? And so that conversation on truth-telling we didn't expect. It certainly wasn't an option that came out or was approved by, but it was their process, so we had to incorporate it within the framework of the dialogue. So we extended it by a number of hours the first day to ensure that people could have their say about the frontier wars and the killing times and the massacres and the protection era, the reserves and the missions. A lot of the old people that were mostly traditional owners who participated in this remembered these periods in Australian history, or very recent history, that law and policy has framed in the lives of Aboriginal and Torres Strait Islander peoples. The other thing to say about the dialogue and creativity is that the constitutional proposal that the Referendum Council took back to the Prime Minister about the voice to Parliament policing or monitoring is a better word, Section 51(26) and the plenary's power 122, no constitutional lawyer had thought of that prior to the dialogues. There was no constitutional lawyer that had thought of that option, and that came up in the course of all the dialogues. My colleague on the Referendum Council, Murray Gleeson, was really fascinated by the really interesting and creative ideas that communities came up with in terms of the options before them and the situation of our peoples on the ground. And I think that really speaks to the dialogue and the way that we ran it. So the dialogue really informed much of what happened. It was intended to absorb criticism and tension and disagreement. So our community is no different to other communities in Australia. We don't all agree. And that was the starting point, is how do you come from different positions and get to some kind of consensus? And the dialogue played a role in that, but so did the record of meetings. And those record of meetings capture all of the disagreement and the tension, and everybody signed off on it. So as I said, we went out to Uluru and we looked at the reforms, and the proposal for reform was voice, treaty, truth, or voice, a voice enshrined in the Constitution, a Makarata Commission to supervise agreement making and truth telling across the Federation. So I know I'm running up against time. I'm going to talk to each of those before concluding. But the first thing I wanted to say was really so many Australians in the 4 years since Uluru come to us and say, wow, what a generous offer the Uluru Statement from the heart is. And really, I think, as a young lawyer at the time, as a junior lawyer, I keep talking about my age, but I feel very old today, I was really struck by the generosity of our old people in those meetings. And I'm not the only person who says that from our community. But where a lot of us younger ones were angry, they were much more conciliatory. And they viewed the Uluru Statement, they viewed voice, treaty, truth as a roadmap to peace. So let me talk to the substance and sequencing of these reform proposals. Obviously, the first reform, which we are currently still in the process of fighting for and advocating for, is a constitutionally enshrined voice to Parliament. Every working group in the dialogue endorsed this as the #1 reform priority. People were surprised that treaty or agreement making wasn't first, but there's lots of really important reasons why that wasn't the case. One was because people felt that native title had had a very damaging impact upon community cohesion, and that people weren't in a position to enter into treaties with the state. So there was a very strong belief that we needed to treaty with each other before we could treaty with the state. Also, there were concerns about the constitutional powers in Australia, that if you don't have, that there were state and territory treaties underway during this process, but people felt that we didn't want to do anything at that Commonwealth level to disrupt that work that was underway. Another issue is that a treaty doesn't need to be a constitutional matter, meaning it might be a small c constitutional matter in terms of constitutional recognition, but it doesn't require an amendment to the Australian Constitution. So the voice was settled upon as a upfront, or front-end political limit on the Parliament's power to pass laws that affect Aboriginal and Torres Strait Islander people. And although people appreciated that there would be no guarantee that these powers would not be used against them in the future in a negatively discriminatory way, it would create a limit through political empowerment that would hopefully lead to better design policies in the future. And that's because although parliamentary sovereignty means we can't bind the Parliament, we would be there at the table. This voice to Parliament would compel the state to have us at the table, and currently that is not the case. And that speaks to a lot of the very poor quality laws and policies that we do have and the very poor outcomes that we see. And we know there are poor outcomes. You only have to look to the closing the gap statistics to know how poor they are. Our people are not at the table. And it's not about putting bricks and mortar in the Constitution. It's an enabling provision. So it's a provision that effectively says, you know, the Parliament shall set up a First Nations voice to Parliament, and those functions and objects, etc., will be determined by the Parliament. So it's a very standard very standard drafting in terms of that provision. But at the core of Uluru is the kind of next step, the Makarata Commission. The Makarata Commission is what we call the culmination of our agenda, the coming together after a struggle. And the idea behind that Makarata Commission is to supervise, as I said, the settlement of agreements between First Nations peoples and the Commonwealth Parliament. We say the agenda for the Makarata would be those very matters identified in the original Social Justice Report of 1995. So the Social Justice Report is what Aboriginal and Torres Strait Islander peoples said to the Commonwealth was repair after the High Court's decision in Mabo. What does repair look like? When you look at that report, it talks to constitutional recognition and many, many things. But that report has never been implemented. The third arm of the Mabo decision, the third social justice package, it has never been implemented. So the voice and treaty were sequenced in that order for good reasons. It was the subject of very diligent consideration in all of the dialogues that led to Uluru. The third element of Uluru was truth-telling, and I've spoken already to that. What I'd like to say about truth-telling is really connected, I think, to reconciliation in this country, and that is people often think it is counterintuitive that truth-telling comes third in the sequencing of the Uluru reforms. And truth-telling is, of course, very important to our people. It has occurred for many decades. But having a Truth and Reconciliation Commission does not mean that truth-telling has occurred or will occur. And I've spoken before about the really acute failures of truth and reconciliation processes around the world. And with my UN hat on, I've seen and read and visited many, many truth processes. And there is this kind of uncritical adoption of transitional justice theory and practice in Australia when it comes to reconciliation and truth-telling. But we're not sure that that applies very well in the Australian context. The Uluru dialogues were absolutely resolute that reconciliation was the wrong word to be used in Australia. Reconciliation means a restoration of friendly relations after a dispute, but it assumes a prior relationship. And as so many people said in the dialogues, we have never met. We have never met. So it's not necessarily counterintuitive that truth-telling isn't first or that it needs to set the foundation. Truth-telling should be happening all the time, but occurring at a pace that is very comfortable to First Nations. What we do know in this country is Australia uses truth-telling as a can-kicking exercise on substantive reform. Australians love truth-telling because our people give so much to it. But at the same time as as in other jurisdictions, when truth-telling is viewed through a healing lens, it neglects to speak to the justice element. And that has happened so many times in Australia, whether it's the Council for Aboriginal Reconciliation or bringing them home, or indeed the apology to the stolen generations. Our people still wait 14 years after the apology for compensation. We accepted Rudd's proposal that he would give the apology and leave the question of compensation to a second phase. And that's a strategic error that was made because the second phase has never come. And so, truth-telling, a strategic decision was made that it must sit as the third part of Voice Treaty Truth, the legal reform proposal that came out of Uluru. So I'm going to wrap it all up so we finish on time. I know Parliament's more on time than academics and universities. I found it really fascinating in going back through the records to read what Neville Bonner had to say about structural reforms, and in particular treaty. I think his concerns about treaty were very much expressed by a lot of people in the constitutional dialogues about what would be treatied on. So there is a serious imbalance of power across the Federation between our people and the state, and whether it really could deliver on the kinds of things that we need to thrive in our communities. But I think his main concern that mirrors the dialogues was the problem of state governments. And so when I reflect on the Commonwealth's preference to call itself these days the ATM, merely the ATM, and that the core responsibility of Aboriginal affairs is with the states and territories, that's deeply worrying for Aboriginal and Torres Strait Islander people. The walking back on 1967, a commitment made by all Australians, that actually the Commonwealth is the primary player in that space. They are not just the ATM. So I saw a lot of really interesting parallels between his concerns about the states and what the Commonwealth is saying now. But most of all was his concern about lack of practical reform. He did not care for symbolism of reforms. He did not care for symbolism. He cared about the practical impact of reforms on the ground in Indigenous communities, and that is what we care about. That is what the Uluru Statement from the Heart stands for. The author of Ethical Loneliness says the past cannot be changed, but it can resound in the present moment in vastly different ways, some of them more hospitable to human thriving than others. She says it's everyone's job to author conditions where repair is possible. And we say, after 4 years, the Uluru Statement from the Heart, the repair set down in that agenda is possible. Repair is possible. And it's now the politicians' job to help author the conditions where repair is possible. We say repair starts here in this building. The word parliament derives from the French word parler, meaning to speak. It is this that animates the Uluru Statement from the Heart, a voice, the right to speak to the democratic heart of the nation, the Australian people, through the parliament. The right of the ancient jurisdictions who have thrived and survived on this continent for over 60,000 years to talk directly to the Australian people. It is an attempt to connect our modern democracy to deep history, and there is no nation on earth that can make such a claim. And this is what the Uluru Statement from the Heart sets down, recognition of this very unique status as a nation. Not reserved seats, not designated parliamentary seats, not more Labor or Liberal politicians, but a First Nations voice to Parliament that can speak to the Australian people via the Parliament and create a dialogue, because it is through dialogue that we can do great things. And I'm going to end now by reissuing to you here the invitation that we gave Australians 4 years ago at the Rock. The Uluru Convention saw the delegates adopt a consensus position on constitutional recognition and then issued a statement, the Uluru Statement from the Heart, to the Australian people, not to the politicians. It was an offer to the Australian people to help us convince Australian politicians of the exigency of the reform, that Australians would walk with us like they did in 1967. And the consideration for this, a voice to Parliament enshrined in the Constitution, is a small price for the benefit that it will unlock for all Australians. We gathered here at the 2017 National Constitutional Convention, coming from all points of the southern sky, make this statement from the heart. Our Aboriginal and Torres Strait Islander tribes were the first sovereign nations of the Australian continent and its adjacent islands, and possessed it under our own laws and customs. This our ancestors did, according to the reckoning of our culture from the creation, according to the common law from time immemorial, and according to science more than 60,000 years ago. This sovereignty is a spiritual notion, the ancestral tie between the land and Mother Nature, and the Aboriginal and Torres Strait Islander peoples who are born therefrom, remain attached thereto, and must one day return thither to be united with our ancestors. This link is the basis of the ownership of the soil, or better, of sovereignty. It has never been ceded or extinguished, and it coexists with the sovereignty of the Crown. How could it be otherwise? That peoples possessed a land for 60 millennia, and this sacred link disappears from world history in merely the last 200 years? With substantive constitutional change and structural reform, we believe this ancient sovereignty can shine through as a fuller expression of Australia's nationhood. Proportionally, we are the most incarcerated people on the planet. We are not an innately criminal people. Our children are aliened from their families at unprecedented rates. This cannot be because we have no love for them. And our youth languish in detention in obscene numbers. They should be our hope for the future. These dimensions of our crisis tell plainly the structural nature of our problem. This is the torment of our powerlessness. We seek constitutional reforms to empower our people and take a rightful place in our own country. When we have power over our destiny, our children will flourish. They will walk in two worlds, and their culture will be a gift to their country. We call for the establishment of a First Nations voice enshrined in the Constitution. Makarata is the culmination of our agenda, the coming together after a struggle. It captures our aspirations for a fair and truthful relationship with the Australian people and a better future for our children based on justice and self-determination. We seek a Makarata Commission to supervise a process of agreement making between governments and First Nations and truth-telling about our history. In 1967, we were counted. In 2017, we seek to be heard. We leave base camp and start our trek across this vast country. And we invite you to walk with us in a movement of the Australian people for a better future. Thank you.
Thank you, Professor Davis. It gives me goosebumps every time I hear that. It's and the passion and the dedication that you can hear through that delivery, I think, is more than a reflection of the tireless work that yourself and Arnie Pat have put into this process, and others here with us today. And just the utmost respect to you all for the drive and to keep it going. So we'll now move to questions. We've got a couple of minutes for one or two questions. And in COVID safe practices, anyone with questions, I'll get you to raise your hand. and then we'll invite you to go over to the microphone and deliver the question, and hopefully not touch the microphone. So do we have any questions in the house at all? Yes, hello. Do you want to head over to the...
Thank you, Megan and Pat and all who have worked so brilliantly and generously on the Uluru Statement from the heart. My partner and I are moved to tears every time we hear that quote. And thank you for your tireless work, past, present, and future. My question is about the voice. While it is not really a voice in the way the Uluru Statement from the heart envisions Indigenous people, there seems to be emerging a voice in Parliament on behalf of women, where women's issues are being considered by special committees, where there are various ministers appointed for various women's issues. My question is, if we can see the evolution of a voice for women in Parliament, what makes it so difficult for us all to see a similar evolution, although not final state, but voice for the Indigenous people in Parliament? Why do we accept the one for women and seem to resist the one for our Indigenous owners? And please don't say it's just because you're black. I mean, try again.
I was going to say that. I was going to say two things. One, I think the voice process is still underway, so we don't know what the model of the voice looks like. What we're advocating for is a constitutional enshrinement of an enabling power before they legislate on a voice. We also advocate for a process that allows Aboriginal and Torres Strait Islander communities to design the voice. That's a really key part of free, prior and informed consent. And it's a key part of institutional design that speaks to hundreds of years of Westminster parliamentary knowledge around legitimacy and trust. So that's not done. That's not finished. Your point on women, though, I mean, I you know, as someone who just criticised theory, I am fond of regulation theory, and I don't, you know, as a woman, I don't think the appointment of spokespeople and committees and other such mechanisms within the parliamentary system or the bureaucracy as being equivalent to progression for women, yeah? Because I think regulatory theory would tell us that that is a part of the ritualism of the public service. They're very good at ritualism, that is to say, here's your spokesperson, or here's this committee, or here's this great poster, put it on a wall. But often that kind of commitment to grand gestures shields a commitment to non-compliance, right? I don't think any of those mechanisms are going to address the problems we have with gender inequality and sexism and misogyny in this house. I'm sorry, I don't. So I don't think it's the best kind of, you know, way to... I don't think... I mean, it's the same reason why in all of the work we've been doing in our submissions to the Wyatt Committee, why we've been saying the creation of another joint select parliamentary committee or standing committee, why that we say it's not going to have a huge impact upon people's lives at the end of the day. I think human rights lawyers make the same point about the Human Rights Committee. They can only do so much, yeah? So we say we need more structural power than just a committee that occasionally sits, doesn't have the resources, doesn't have the time, doesn't have the budget to do the work that's required to keep people accountable for the really poor decisions and practices that are made that keep our people down. That would be my first initial response to your... I mean, I think what the appointment of those kinds of things does is it takes the heat out of it politically. Yeah. So people don't talk about it anymore because they think, oh, it's being dealt with.
Thank you. We have, better make this the last one, and then we'll wrap it up.
Thanks for a fantastic, revision of what has been happening and what has not been happening. I wonder if you had ever had an opportunity to speak with Malcolm Turnbull and to get an explanation for his behaviour around the Uluru Statement, because it had such potential. We've seen how it moved everybody here today, and whether he would change his mind now.
So everybody asked about Malcolm Turnbull, but I've got two responses to that question. One is, well, he's no longer Prime Minister, but this is three things. He's no longer Prime Minister. The second thing is, straight after Malcolm Turnbull made that comment, you know, the Uluru Statement went into a joint select parliamentary committee led by Lisa and Dodson, who went around the country and spoke to lots of people and, you know, concluded that this was the only viable form of constitutional recognition on the table, but they also said you needed more meat on the bones before you could go to a referendum on a voice. My point being is that 4 years later we're here and we're strong and more Australians are coming on board. So Malcolm's issue, you know, hasn't deterred us. You know, I mean, there's very few Aboriginal political agendas where a politician says no and we go, okay. But I think Noel said it best during the Sydney Peace Prize. He said, you know, all that reflected at the time was the torment of Malcolm Turnbull's powerlessness. And at the time, he couldn't do anything in his party room. He squandered all of that goodwill from the Australian people and he couldn't get them across the line on anything, let alone this. So I don't think it's a reflection on the Uluru Statement from the heart. I think it's a reflection on his leadership. And I had a third thing, but I can't remember what it was. Oh, no, he doubles down on it all the time now. So he does the, you know, it violates equality, it violates democracy, you know, he's got a little spiel. People hit him up about it all the time, but I don't think he is going to move on that point, which is fine. He's entitled to his opinion. He's just wrong, that's all.
And on that note, I think we have run out of time. Can I thank you again, Professor Davis, for your lecture. I couldn't think of a more fitting way to honour Neville Bonner and his contribution to the Parliament and Australia. Thank you very much.